Hello, my name is Dan McMichael. The Bar Association of Metropolitan St. Louis has participated in the development of this tape to help you prepare for a deposition. We will explain some important points and illustrate them with dramatizations from excerpts of actual cases. The detailed facts of the cases are not important. The purpose is to acquaint you with procedures in giving testimony. A deposition is a formal interview of a party or a witness in the case under oath by the lawyers. During the deposition process, the lawyers develop a better understanding of the facts of the case and develop an opinion as to what sort of an impression the witness will make at the time of trial. If a case cannot be settled, the deposition is a very important tool to the lawyer in preparing the questions that he asks at the time of trial. Generally, it is damaging to a witness to say something different at the time of trial than he says at the time of deposition. Therefore, it is very important that you listen carefully to the question that is asked and be certain that you understand it. Then you need to answer the question as simply and directly as possible without unnecessary elaboration. In that way, you will minimize the chances that you'll say something damaging to your case. This is a typical setup for a deposition. It is ordinarily the conference room of one of the lawyers involved in the case. You will sit here, and your lawyer will sit next to you. The lawyers asking questions will sit on the other side of the table from you. A court stenographer usually sits between you and the questioning attorneys. Only one lawyer at a time can ask questions. You will be testifying under oath. The court reporter is there to record everything that is said. At least one lawyer from each firm has a right to be present, and the parties to the case have a right to be present. Mere spectators who are not parties or lawyers for parties do not have a right to be present. Although in a small case, the lawyers may not object to a spouse or a parent being present to lend moral support to a witness. In any event, don't let these people distract you. This is your deposition. Now we're going to show you several examples from actual depositions. During certain points, you will see a graphic like this. This will give you some rules to remember. Try to imagine you're on the jury and make a mental note of the impression that the witness makes. Ready?
My client, Lester Ruthful, tripped on some loose carpeting at the Monarch shopping mall and sustained a serious injury to his right knee. He sued the mall for negligence.
Mr. Ruthful, my name is Martin Younger, and I represent the Monarch shopping mall in the suit that you filed against the mall. I'll be asking you a series of questions about yourself and the incident. Do you understand that we'll be making a written record of what is said here today?
Yes.
Do you understand that we may refer back to this record at the time of trial?
Yes.
If at any time you have a question or you don't understand a question, please ask me to explain. If you want to take a break, please say so. Do you understand?
Yes.
Please state your name and current address for the record.
My name is Lester T. Ruthful, 1776 Cherry Street, Webster Groves, Missouri. Well, when I tripped over the rip in the carpet, I tried to catch myself and I grabbed for the first thing that I could, and that was the rail of the escalator, and it was moving. And I twisted and I felt this horrible pain in my right knee and this tearing sensation.
Have you at any other time sued for personal injury loss?
No.
Have you at any other time sued for personal injury?
No.
Any incident at all where you sued for personal injury?
No.
Mr. Ruthful, are you the same Lester T. Ruthful residing at 1776 Cherry Street in Webster Groves, Missouri, that filed suit in St. Louis County in a case styled Lester T. Ruthful versus 4-Ply Lumber Company, bearing cause number 83-237?
I don't remember that.
Do you recall that your attorney was Mr. John Jones and that you sued for $500,000 and settled the case for $175,000? According to official court record on file, January 15th, 1984.
Well, of course, now that you mention it, yeah, I remember it, but I didn't think that an injury to my left hip would have anything to do with
Your
this
Honor,
case.
I would ask that the last portion of that statement be stricken as not responsive to the question asked.
That motion is sustained. The second part of the question is to be stricken from the record, and the jury is to disregard that statement.
Mr. Ruthful, do you remember filing suit in St. Louis City in a case styled Lester T. Ruthful versus Baggs Grocery Company, cause number 862-8932?
Your Honor, I object. That suit involved an arm and a wrist injury and is not relevant.
Your Honor, this goes to the witness' credibility and ability to recall and tell the truth.
The objection is overruled. This does go to the credibility of the witness. Mr. Treitel, you are not making a speech to the jury. You will make legal objections. If you wish to argue your motion, you will come to the bench or risk citation from this court. Do you understand?
Yes, Your Honor.
Your Honor, at this time I have no further questions, but I would ask that Exhibit 21, which is a certified copy of the St. Louis County court file styled Lester T. Ruthful versus 4-Ply Lumber Company, cause number 83-237, and Exhibit 22, which is a certified copy of the St. Louis City court file styled Lester T. Ruthful versus Baggs Grocery Company, cause number 862-8932, be admitted into evidence.
Object to the relevance, Your Honor.
The objection will be overruled. The exhibits are admitted.
The jury found for the Monarch Shopping Mall.
Nobody believed Mr. Ruthful, and he lost his case. Now, let's see what should have happened.
Mr. Ruthful, have you at any other time sued for personal injury loss?
Yes.
What were these suits about?
Well, I broke my hip at the 4-Ply Lumber Company when a forklift truck loaded with lumber hit me when coming around the corner in their warehouse. That was in '83. And in '86, I was rear-ended by a Baggs grocery delivery truck at a stoplight. I broke my arm and my wrist.
Have you at any other time sued for personal injury?
Your Honor, may we approach the bench?
Come forward.
Your Honor, Mr. Ruthful has candidly admitted in his deposition that he's been involved in 2 other lawsuits. The injuries in those other lawsuits involved his left hip and his arm and wrist. They are clearly not relevant to this case, and I'd ask that they not be gone into in front of this jury.
The motion is sustained. Mr. Gotch, all those are unrelated matters, and you will not go into them in this courtroom.
Yes, sir.
Lester received a cash award for substantially more than his settlement demands for the mall's negligence.
My client is Miss Cora Vince. She was involved in a car accident near Main and 21st Street. She was going east on Main Street and had already passed 21st Street. At that time, Mr. Ira Blaster was attempting to make a left turn to go east on Main, the same direction as Cora. He ran into the driver's side of her car. She had her seatbelt on, but she did sustain a serious whiplash injury.
At the time of the impact, was your vehicle within the intersection, or had you already crossed?
No, I was about 2 or 3
21st Street.
No, that isn't the place.
Cora, let her finish her question before you answer it.
Okay.
Make sure you're answering what she's asking.
Okay.
So your car had crossed both the eastbound and westbound lanes of 21st, and you're on Main Street.
I was on Main. Mm-hmm.
Okay, so you're about 2 or 3 car lengths past the intersection, but before...
Right. Oh.
So you're north of the intersection.
That's right.
And a car comes from your left and hits you in what portion of your car?
My front door, the front part of it, and the end of it right before it meets my fender and my mirror.
Do you know where this other car came from?
From my left.
Did it come from the filling station, which is over there?
I honestly don't know, but I do know what he told me, but I guess that doesn't count.
Tell me exactly when you first saw this other car. Was it before the impact?
Oh, I'd seen him when he hit me. I mean, when he came for me, I said, my God, please don't let him hit me. And then he hit me.
After the accident, did he say anything to you?
Well, his girlfriend and himself were in the car, and they both got out. And the first thing he says is, look at my car, what you did. Well, I was so dumbfounded because I couldn't even get out of my car because I'd been hit so hard.
Cora, she just wants to know if the guy said anything. Just answer the question.
Well, that he hit me, that I hit him.
Did he say anything about where he had come from?
No. He just said, where did you come from? That's all.
Did he ever say anything about contacting the police?
Because when I got out, I asked, because I said I got hurt. And I said, the first thing we need to do is exchange things, and then I'll go across the street and call the police. And someone said the police were called. Now, I'm telling you, that is exactly what happened. You have got to believe me, because that is exactly the way that it was.
Did he tell you that he was going to go home and get some proof of insurance?
Or his license, yeah, because he didn't have nothing with him. Just a girl was in his car, her and her mother. I found out later that that was her mother. And they said that she would talk to that they would talk to the police at the same time that I was there.
Was it raining or sleeting at that time?
Oh, it was awfully cold. I mean, I was trembling. I was so cold. But I went across the street.
She's just asking if it was raining or sleeting at the time.
Well, hey, it was probably raining and sleeting.
You called your daughter?
My daughter.
Why did you call your daughter?
Oh, because I was supposed to pick her up at 3:30, but then I had a telephone call and that slowed me up just a little bit. And now I had to call her and tell her what happened to me and that she'd have to come and pick me up instead.
So how fast were you going, Miss Vince?
Cora Vince's lawyer had to settle this case for only a fraction of what she would have ordinarily expected.
Now we'll see Mr. Jerry Rigg, who's applied for medical insurance while between jobs. Mr. J. Bird, a representative of a medical insurance company, sold Mr. Rigg the policy. Mr. Rigg's daughter was diagnosed as having leukemia. When he sent in his claim, the insurance company refused to pay for what they call a pre-existing condition. Mr. Rigg is suing Mr. Bird.
Mr. Rigg, you've stated that you spoke with Mr. Bird several times. When exactly did you first speak with him?
I don't remember. It was sometime in the beginning of the year.
When at the beginning of the year?
I don't remember.
Would it have been in late January?
No, not late January. It was early January.
Well, what is early January? The 10th? The 12th?
No, earlier than that.
Well, Mr. Rigg, you're going to have to think back. On what day in January did you first speak with Mr. Bird?
Well, like I told you, I spoke to him right from the beginning, and then several times after I got this worthless policy.
Now you say from the beginning. What was the date that you first spoke with Mr. Bird?
I don't remember the exact dates. I talked to a lot of insurance companies between January 4th and 6th.
So when you spoke with Mr. Bird, you were searching for coverage?
Yes, I called all over. I was looking for good rates and maximum coverage.
And you were hoping to find maximum coverage quickly?
I'm going to object. There's no indication that he was in a hurry to buy medical insurance.
Well, yes, I was. I needed coverage by the end of January.
The end of January, that's when your daughter was going in for more tests?
Object again. There's no indication that Mr. Rigg's daughter's condition existed before the end of January.
Mr. Rigg, was your daughter ill at the beginning of the year?
She had a touch of the flu, but, well, that's not why I'm here. I've changed jobs recently in my old coverage.
Mr. Rigg, I need the exact dates and times that you first spoke with Mr. Bird or any other representative of the company.
I told you, I can't remember. I got more on my mind than the date I talked to that no-good son of a...
Mr. Rigg, we're going to have to break here so you can collect your thoughts, okay?
No, I don't need any break. My thoughts are all collected just fine.
Mr. Rigg, can you give me the exact date at which time you first spoke with Mr. Bird?
How many times do I have to tell you? I don't remember.
We need the exact dates and times, Mr. Rigg.
Exact dates and times. You want exact dates and times? How about the exact date I'm going to have to sell the house to pay the bills?
Take a break.
Or the exact date I'm going to have to stop my daughter's treatment? Or the exact date my daughter's going to die? Please? Is that what you want?
It was established that Mr. Rigg's daughter had a pre-existing condition.
My client, Mildred Meeks, was involved in an automobile accident with Mr. Quasley. They were both driving north on Airport Road. Mr. Quasley was some distance in front of Ms. Meeks. There had been an accident earlier in the southbound lanes of Airport Road. Mr. Quasley had pulled off onto the shoulder directly across from this accident scene. There were police there directing traffic around a stalled car. Ms. Meeks alleges that as she approached the site, Mr. Quasley suddenly and without any warning pulled out onto the roadway in front of her. She says that she was unable to stop, she hit him, and she was injured in the accident.
How fast were you traveling immediately before the accident?
Well, if you characterize my client's speed as fast.
Well, subject to that, you can answer.
Go ahead.
30 miles per hour.
Did you have a passenger in your car at the time?
Yes.
And were you having a conversation with that passenger at the time of the accident?
Yes.
Can you tell me what you remember about the scene of the occurrence immediately before the impact?
I remember as I was traveling down the road, a police officer was over there directing traffic around a stalled car. And I remember looking at all the people standing around the stalled car before we came up to the scene where we had the accident.
Okay, you have to answer out loud. The court reporter can't take down gestures. So you have to state what you were, where you saw the police officer.
Oh, on the left.
Now, when did you first notice the defendant's vehicle?
Immediately when he pulled out in front of me.
Okay, let me see if I got this straight. At the time of the collision, you're going 30 miles an hour. You're talking to your passenger. You're looking out the side of the window at a stalled vehicle and the police officer's directing traffic. You never saw the defendant's car until the accident happened. You were traveling at 30 miles an hour, and you had the impact. Is that right? Is that correct?
No, I'll object. That totally misstates her testimony. Go ahead. If that's your testimony, you can answer.
That's not correct. All these things didn't happen at the same time.
Isn't it true that after the accident, the police officer asked you what happened? You said that your attention was diverted immediately before the occurrence.
Wait. I'm going to object to you. Let her answer a question. You're harassing her, you're arguing with her, and if you'll just give her a second, she's a little nervous here, and I think that she can answer your question if you'll just give her time.
I think the question called for an answer. She was about to answer in a way that wasn't proper. I think it called for a yes or no answer.
Now, wait a minute. Now, your question started with what? I think it was, what was the diversion? That's not a yes or a no.
As she said, there was a diversion. It's in the report. I want her to tell me what it was.
Then let her answer.
Fine, just a yes or no.
Okay, and of course the police report will speak for itself, but go ahead, you can answer.
I guess it's what you said. What you mentioned earlier was in the police report. I guess.
Did you ever slow your vehicle?
No, I had no idea he was going to pull out in front of me.
You didn't honk your horn?
What for?
I'm just asking you. I'm not accusing you of anything.
No, I mean...
I'm just asking you a question. Did you honk your horn?
But I'm asking, why would I honk my horn?
No. The good thing about depositions is this. I ask the questions, you answer them. So I ask you again, did you honk your horn before the accident?
No. Stop harassing her. Go ahead and just answer the question.
No, I did not.
Thank you.
This case went to trial but resulted in a hung jury. All were sympathetic, but four thought that Mrs. Meeks was tentative and uncertain of herself and probably was not paying attention.
In this case, my client, Billy Jarrett, is a defendant. BLDG Corporation is suing Billy Jarrett of the Go Away Travel Agency for defaulting on a lease he signed. Billy Jarrett claims that he didn't sign it as an officer of the company.
Right. Would you mark this Exhibit 4 for identification, please? Thanks. Sir, I'm handing you what has been marked as Exhibit 4 for identification, and I'm also going to give your lawyer a copy of it. Exhibit 4 appears to be an agreement to incorporate the Go Away Travel Agency dated January 9 of 1990, signed by you. Would you please look over Exhibit 4 and take all the time you need? Let me know when you're finished.
Okay.
All right. Now, sir, you did receive a copy of this Exhibit 4 when you signed it, did you not?
Well, I didn't receive one, no. But I always keep a copy of everything I sign.
Telling me that you did not receive a copy of Exhibit 4, but you kept a copy, is that right?
No, that's not correct. And I don't have a recollection of signing any document like this.
All right, well, let me see Exhibit 4, sir. That is your signature at the bottom of the last page of Exhibit 4, is it not, sir?
Well, yes, that looked like my signature, but I don't remember signing anything like this. What's this document supposed to be again?
Ms. Johnson, will you read back the description of Exhibit 4 that was made at the time of entry into the record?
What? I'm handing you what has been marked as Exhibit 4 for identification. I'm also handing a copy of Exhibit 4 to your lawyer. Exhibit 4 appears to be an agreement to incorporate the Go Away Travel Agency dated January 9, 1990, signed by you. Would you please look over Exhibit 4, take all the time you need, and let me know when you are done?
Sir, did you take all the time that you needed to read Exhibit 4 when I first handed it to you?
Well, I can't say that I did.
And you did, in fact, sign this Exhibit 4. Is that correct, sir?
No, in fact, that is not correct.
You did not sign this Exhibit 4?
No, I did not sign that. That's a photocopy, and I never sign photocopies.
Okay. You did, in fact, sign the original document of which Exhibit 4 is a photocopy. Did you not, sir?
Yes, that is correct.
All right. And you signed it as Billy Jarrett, Secretary. Is that correct?
No, I did not. I signed it Billy L. Jarrett.
But that is your signature on Exhibit 4, is it not, sir?
Well, as best I can see across the table, it is.
Mr. Durant, as Go Away Travel Agency, was ordered to pay the leasing company for the full amount of back rent and all attorney's fees and interest.
We're getting ready for a deposition here today in a case called Brawley versus Rush. This is a case involving my client, Mr. Frank Brawley, who was involved in a two-car accident on Manchester Road near I-270 with Mr. Rush. Both cars were traveling in a westerly direction at the time the accident occurred. Mr. Rush allegedly made a left-hand turn in front of Mr. Brawley, cutting Mr. Brawley off. My client was steamed.
Mr. Brawley, which lane were you traveling in when you first saw the defendant's car?
I was in the left lane.
And how long have you been traveling in that lane?
About a half a mile since Limburg.
Were there any other cars on the road near you?
No, he just pulled in front of me.
Well, why were you traveling in the left lane? Isn't that normally the lane for passing?
Normally, yeah.
Why, if no one was in front of you, were you traveling in that lane then, sir?
No particular reason.
Can you tell me exactly where the collision occurred on the highway?
Just past the intersection of Wren.
And which lane did it occur in?
The right lane.
Had Mr. Rush turned and left in front of you earlier, sir?
Yeah, but that was a long time before the accident.
Well, were you upset because you felt that he had previously cut you off?
Yeah, I was upset with him.
Were you yelling at him from your car?
Yeah, but what are you trying to...
Do you frequently get upset with people?
Listen, what are you trying to get at?
Sir, please just answer the question.
Look, you must think I'm some kind of hothead. You must think that he pulled in front of me, and then I pulled back in front of him and cut him off, and that's what caused the accident. Is that what you're trying to say?
Thank you, sir. You stated previously that this blue car pulled out from your left.
Yeah?
Did anyone else see this car?
Yeah, somebody else had to have seen it. What is Rush trying to say? Nobody else saw it?
Sir, how long before impact did this car pull out in front of you?
I don't know, not long.
Only minutes and seconds. How long would you say it was?
Objection. That's about a minute. It was about a minute. I guess about a minute.
What did you do?
And then I pulled over in the right lane. That's where the accident happened. He rear-ended me in the right lane.
Do you have any idea how fast you were traveling when this alleged car pulled out?
35 miles an hour. I always go to speed limit.
Was it possible that you were going 45 that day?
I never speed.
Mr. Brawley, when you first saw this vehicle pull out from your left, what did you do?
I was in the right lane. That's where the accident happened, in the right lane.
Well, can you describe for the jury what your movement was?
I don't know. It was quick.
Well, roughly minutes or seconds. Could you narrow it down in that way?
I don't know. Less than a second.
Well, do you remember giving a deposition at my office?
Yeah.
Remember you were under oath at the time, sir?
Yes.
Sir, do you remember being asked these questions on page 23 of your deposition? Question, now you say this blue car pulled out from your left. Answer, yes. Question, how long before impact did this car pull out in front of you? Answer, not long. Question, how long in minutes or seconds? Answer, I guess about a minute. You remember being asked those questions, sir?
I didn't understand the question when you asked it,
Well, do you also remember being asked these questions at the beginning of the deposition? On page 2. Question, if at any time you don't understand a question, please feel free to ask for an explanation. Do you understand? Answer, yes.
Hey, the deposition was really long. It was very uncomfortable.
Well, sir, do you also remember being asked this question on the same page? Question, do you understand that you may ask for a break anytime you feel you want or need one? Answer, yes. Do you remember being asked that, sir? Mr. Brawley, what speed were you traveling at the time this accident happened?
35 miles an hour.
Well, isn't it possible that you were actually traveling 45 at the time of impact?
I never speed.
You never speed? Isn't it true, sir, that you've been convicted of 2 speeding violations in the city of Manchester just in the last 6 months?
Mr. Brawley was found to have been the cause of the accident.
Now here's George Fitzsimmons from the law firm of Gray & Ritter with some additional information.
You should also consider what to wear and what kind of impression you make. A deposition is always more casual than court, but not so comfortable that you forget why you are there. The impression you make on the attorneys present is important. Be yourself. Speak clearly. And look at the person asking the questions. Anything that you do or say should project an image of confidence about yourself and your testimony.
Just remember, a juror is an ordinary person off the street just like you. They've sacrificed their time in order to fulfill their civic duty and help decide your case. If they feel that you are honest and direct and you're not trying to take advantage of the system, they'll want to find in your favor. If, on the other hand, they think you're exaggerating or you're being anything less than honest about even the most minor side issue, they can turn against you. That's because the trial of a case is as much about the parties involved in it as it is about the facts of the case. So, remember, listen to each question and be certain that you understand it before you answer it. Then when you do answer it honestly, simply, and directly, without any unnecessary elaboration. That's your job. Leave the argument and the advocacy to your lawyer. That's his job. If you have any comments about this tape, please let us know at this address. Tape comments, 300 Chesterfield Center, Suite 240, Chesterfield, Missouri, 63017.